Yes, Mr. McGee.
My Lord, my Lady, in these appeals, I appear with my learned friend Mr. Radley Gardner, Mr. Tippler and Miss Hemmons for Cornerstone in both what I shall call the Compton appeal and the Ashlock appeal, although I should say that Mr. Radley Gardner and Miss Hemmons are instructed only in respect of Ashlock, not in respect of Compton. Myself and Mr. Tippler are instructed in respect of both. My learned friends Mr. Seatler, Mr. Kitson and Mr. Lees appear for On-Tower in what I'll call the On-Tower appeal. And my learned friends Mr. Pymont, Mr. Clark and Miss Schofield appear for AP Wireless. And AP Wireless are here in three capacities. First, as intervener in the Compton appeal. Secondly, as the second respondent in the Ashlock appeal. And thirdly, as the respondent in the On-Tower appeal. Compton Beauchamp Estates Limited, the respondent in the Compton appeal, is not participating in the appeal, as your lordships will be aware. Ashlock Limited is not participating in the Ashlock appeal. It has agreed to be bound by any code agreement imposed on AP Wireless. The other thing I should tell you is that Ashlock has recently transferred the property to Gateway Properties Limited, and it has similarly agreed to be bound by any code agreement imposed on AP Wireless. As you'll be aware, this is the first occasion that this court has had the opportunity to consider the scope and effect of the Electronic Communications Code or its predecessor. And again, as you'll have seen from the papers, that the Electronic Communications Code is in force as from the 28th December 2017 and is contained in Schedule 3A of the Communications Act 2003, inserted by the Digital Economy Act 2017, and replaced the old code, which was in Schedule 2 of the Telecommunications Act 1984. The new code was enacted because the government recognised the importance for economic growth of public access to high-speed fixed lines and mobile network services. Although we're concerned with mobile network operators here, it's important to bear in mind that fixed line operators, cable and fibre, are also covered as well. It arose out of dissatisfaction with the old code in that it was making the rollout of new technology more difficult. And therefore, the new code was enacted specifically to promote the investment in physical infrastructure necessary for network services in two ways. Firstly, by making it easier for operators to get rights to install and maintain equipment. Part of this appeal is that if the Court of Appeal is right, these things are made rather more difficult. And secondly, by reducing deployment and operational costs. And that's all explained and summarised in the Court of Appeal judgments and in the Law Commission report number 336 that gave rise to it, and I'm not proposing to take your lordships.
No, you can take it that the panel will have read the parties' cases and the judgments below. We're familiar with the general background, and the issues which concern us, obviously, is the language used in the different parts of the modern code and its relationship to the transitional provisions in Schedule 2.
Lord, I appreciate that, and I'm going to spend 95% of my submissions taking your lordships and my lady to the new code, the relevant provisions of the old code, and the transitional provisions.
Thank you.
Rather than seeking to appeal to broad issues of policy. As your lordship will have seen, there are two issues in the appeal. The first is that the Court of Appeal in Compton decided that an operator with electronic communication apparatus on land, ECA, and a sufficient physical presence and control was to be treated as the occupier of the land for the purposes of paragraph 9 of the code. And secondly, that code rights could only be conferred by the occupier of the land, so that if the operator was the occupier of the land, it couldn't obtain code rights either voluntarily under paragraph 9 or by order of the tribunal under paragraph 20. The second thing it decided was that to be an occupier, a person only needed to have sufficient physical presence and control, whether or not it had a right of control. And therefore, it would follow that a squatter could, in principle, be an occupier. That led the court in Compton to conclude that Vodafone was the occupier, although we say it had no rights of occupation at that stage. And those decisions were followed in Ashlock and on Tower, so that in Ashlock it was held that Cornerstone was an occupation and therefore couldn't make an application under paragraph 20, and in On Tower that On Tower, or Arkiva as it was then called, was an occupation and it couldn't make an application under paragraph 20. We have two distinct arguments. The first applies to all three appeals, the second only applies to the Compton appeal. Our principal argument is that an operator with ECA on land is not, within the true meaning of the code, to be treated as the occupier of the land for the purposes of paragraph 9, and therefore it can acquire rights voluntarily under paragraph 9, and the tribunal can order those rights in its favour under paragraph 20. And on that basis, if we're right on that, we should succeed in the Compton appeal and the Ashlock appeal, and it also means that Malone friend Mr. Siegler should succeed on the On Tower appeal. The second argument applies only to the Compton appeal. We say that to be an occupier of the land, a person needs to have not only sufficient physical presence and control, but also a right of control. And in Compton, we say it did not have a right of control. Vodafone didn't even have a right to enter the land to maintain or repair its ECA, and it was only there lawfully pending an order for its removal. If we're right on that, then even if our principal argument fails, the Compton appeal should succeed, we say. So, Lord, my lady, I'm going to turn now, if I may, to the relevant provisions of the code. Firstly, give you a quick bird's-eye view of the key structure of the code, and then go on to the particular provisions that we say indicate that the intention of the legislature was that an operator with ECA on land was never to be treated as the occupier of the land. But before we do that, it's necessary to understand the structure of it, which I think I can do very quickly. It starts at page 1813 of the bundle. And it's divided into...
Before you go any further, Mr. McGee, as you've sort of given us the outline, can I just ask this question? It may be obvious. In the other case, the On Tower case, the main argument you're putting forward is relied on as an alternative.
Yes.
The primary argument being put forward is something rather different, which I might summarise by saying something to do with the interpretation of relevant person.
Indeed.
In the event that we would not be with you on your submissions, would you adopt the relevant person argument to support your appeal?
Yeah.
You don't actually specifically say that you do, but it would seem a bit odd if you didn't.
Yes, well, Lord, I agree. We're happy to win which way. It's the short answer. We didn't put that in our case. We don't have permission to argue the point. We are right behind my learned friend Mr. Siegler, so that if I fail dismally, but he succeeds, then so ought all three appeals. There are some differences in the results of my analysis and of my learned friend Mr. Siegler's analysis in the effect that they would have. I'm happy to deal with those now, but I think it might be sensible if I go through what I say are the various problems with the code, which are all solved by my solution, and then perhaps I can touch on the extent to which those things are solved.
Yes, well, we would wish to know the consequences of your argument and also the On Tower argument at some stage. I was going to leave the question which Lord Burrows has asked you for later, but it is one for which we need an answer, and I think you've given it. Yes.
Lord, I was intending right at the end of my submissions to deal with the question, because my learned friend's got more than one argument. He's got the relevant person argument, he's got two other arguments as well, and we're going to deal with what the effect of his arguments would be if they succeed, and the answer is nearly as good as mine, but not quite as good as mine. The arguments themselves maybe put rather better, but that's another matter. So what I was going to turn to was the outline of the code starting at page 1813. And your Lordships see it's in a number of parts. And starting with part 1, can I go straight to page 1814, which is paragraph 3? That sets out a list of what can be code rights. So an operator can seek one or more of those codes rights. And it's a right for statutory purposes to do various things. Install ECA, keep install ECA, inspect, maintain, etc., carry out works, enter the land, connect to a power supply, interfere with access, find or unlock or cut any trees, etc. Obviously, the first one, A and B, install and keep installed, are the most important. Secondly, paragraph 3 says you can do that for the statutory purposes. Paragraph 4 makes it clear that there are two types of statutory purposes. One is to provide an operator's network. The second is to provide an infrastructure system. So in the present case, both OnTower and Cornerstone are not mobile network operators like Vodafone EE. They are wholesale infrastructure providers who provide the hardware, and then people like EE and Vodafone will come along and use the masts under an arrangement with Cornerstone or OnTower. It provides for both. Of course, it also provides, as I said earlier, for fibre and cable. So that's paragraph 4. Paragraph 5, a definition of ECA, electronic communication apparatus. Can I simply ask your Lordship to note at this stage that paragraph 5.1d, it includes other structures. And if one turns the page, 5 sub 3 contains a definition of structure which includes buildings if the sole purpose of the building is to enclose other ECA. And that will be important. Then we get to part 2, which deals with the conferral of code rights as defined in paragraph 3 by agreement. And the key provision, probably the key provision in the whole code, is paragraph 9, which provides that the code right in respect of land may only be conferred on the operator by an agreement between the occupier of the land and the operator. And that's where we see that reference to the occupier of the land, which will be the key provision to construe. So rights have to be granted by an occupier. An occupier, of course, may or may not have an interest in the land, may or may not, even if it does have an interest in the land, an interest that's sufficient to grant those rights. So how do they bind other people? And the answer is paragraph 10.4 over the page. The code right also binds any other person with an interest in land who has agreed to be bound by it. So those are the two key limits, paragraph 9 and paragraph 10.4. And then while we're at page 1816 at the bottom, paragraph 11 provides that an agreement granting code rights has to be in writing. And in sub 2, that applies also to any variation of that agreement. So those are the key provisions. And then there are a number of provisions of the code, some in part 2 and some in part 3 that we'll come to in a moment, that deal with the special characteristics of code rights. The first one that we see in part 2, which is in paragraph 10, starting at 1815, there are special provisions as to how successors in title of the occupier or successors in title of the person who has agreed to be bound are themselves bound. There's nothing particularly special about those that I need to point out at the moment, but there is a special statutory way. These are not property rights, and this becomes an important point. These are special statutory rights created by the code, and they are treated in binding successors in particular circumstances. So that's the first characteristic. The second characteristic we see from page 1817, paragraph 12, sub 2, that anything done by an operator in exercise of a code right is treated as being done in the exercise of a statutory power. So whatever's done is lawfully done in the exercise of a statutory power. Paragraph 14 over the page 1818 provides that there's no need to register those in the land register. Again, they're statutory rights, they're not property rights, and so they're binding whether or not they're protected by registration at the land registry. That's the third characteristic.
Sorry, which paragraph was that?
Sorry, paragraph 14, my lord.
14?
Yes, and indeed, my learned friend Mr. Piemont, in his skeleton argument, describes the rights in question as sui generis statutory rights, and we'd gratefully adopt that expression. So that was the third characteristic. The fourth characteristic we see in paragraph 16, which is that the agreement granting the code rights cannot effectively prevent assignment. It's void to the extent that it prevents or limits its assignment of the agreement to another operator or makes assignment subject to condition. And then there's various provisions about, but that doesn't mean you can't have a guarantee on an assignment. But it's that short point that one of the special characteristics of code rights is that they are assignable, and there's nothing in the code agreement one could do to prevent that. And then the last one we see in paragraph 17, which is possibly the most significant, is this. Let me summarise and then take your lordships to the relevant parts of it, which is it provides minimum rights for the operator to upgrade or to share. So it says an operator may, if the conditions in subparagraphs 2 and 3 are met, A, upgrade the ECA, or 2, share the use of the ECA with another operator. And the conditions are, first condition, no adverse impact or no more than minimal adverse impact on its appearance. And the second condition, no additional burden on the other party to the agreement. And one sees in sub 5 that an agreement which purports to prevent that happening is void, or one which puts it subject to conditions is void. So, as I say, this was an important part of what lay behind the code, that technology changes. There's the rollout of 5G, for example, as far as mobile operators are concerned, and Parliament wanted to make sure that there was an automatic right to upgrade, and also, that's particularly relevant for wholesale infrastructure providers, that they had an automatic right to share it with other people as well, so it was there for the benefit of the public. However, those rights were circumscribed. So often in code agreements, and there are authorities on this at first instance, often in code agreements, the operators will seek rights that go wider than the minimum rights set out in paragraph 17. But nevertheless, there are those rights. So I've set out 6 special characteristics of code rights that come from Part 2 and Part 3 of the code.
Is there a definition of when something is being upgraded, or is that just a term?
No, I
assume everyone knows what it means.
Lady, I don't think there is a definition of that. If I'm wrong, I'll be corrected. Mr. Radley Guardian wrote the book on the subject, so he'll tell me if I'm getting that wrong. The next part of the code is Part 4, which starts at page 1821. So far, we've been dealing with code agreements entered into by agreement and their special characteristics. Part 4 provides as to what is to happen if the operator and the land owner or site provider can't agree on whether there's to be agreement or on its terms. And the key provision is paragraph 20, sub 1, on page 1821. And this introduces a new definition, relevant person, and says this paragraph applies where the operator requires a relevant person to agree, A, to confer a code right on the operator, or B, to be otherwise bound by a code right which is exercisable by the operator. We say, in agreement, I think, with Mr. Piemont, but not, I think, with Mr. Seitler, that the reference to confer a code right is to reflect paragraph 9, that is to do by compulsion what the parties can do voluntarily under paragraph 9, and that paragraph 21B reflects paragraph 10.4, that is, it enables the tribunal to order people to be bound if they don't agree to be bound under paragraph 10.4. So we accept, therefore, that so far as the conferral of rights is concerned, by compulsion by the court, that it's a compulsion, an order made against the occupier of the land. And so it takes one back to paragraph 9. And then paragraph 21 sets out the 20 sub 1 and following sets out the procedure. The operator is to give a notice in writing to the relevant person, and then, failing a favourable response within 28 days, the operator can apply to the court, which in practice means the Upper Tribunal. And then subparagraph 4 provides that an order which imposes on the operator and the relevant person an agreement between them, which either confers a code right or provides for the code right to bind a relevant person. So one might have a situation where the occupier has agreed, but the landowner won't agree. So you have a paragraph 9 agreement, but you need to go under paragraph 20 to make the landowner back. Now, there is a test that needs to be satisfied before the court can make that order, and that's paragraph 20, set out in paragraph 21. It says that the court may make an order under paragraph 20 only if two conditions are satisfied. The first is that any prejudice caused to the relevant person is capable of being adequately compensated by money, and the second is that the public benefit likely to result from the making of the order outweighs the prejudice to the relevant person. And in relation to that second condition, sub 4 says that the court must have regard to the public interest and access to choice of high-quality electronic communication services. So, in order for the tribunal to be able to make an order at all under paragraph 20, it must be satisfied that the first and second conditions are satisfied. If they are satisfied, then we say it has a discretion whether to make an order, because it says in sub 1 the court may make an order, and I'll develop this point if necessary later on, rather than it must make an order. And then paragraph 22 provides...
Just before you go on, can you just give me an example of where you've told us that paragraph 20 includes the situation where the occupier has agreed,
yes,
but the landowner has not agreed. Can you just give me an example of how that would work?
An example might be of that the land in question is tenanted under a monthly periodic tenancy, and the tenant is quite happy for a huge mast to be put on the land that it's occupying under that tenancy, but the landowner is very unhappy with it. Indeed, it might be contrary to the terms of the tenancy. You might only be allowed to use it for grazing sheep, but the occupier has said to the mobile phone operator, yep, I'm very happy if you do that, I'll enter into a paragraph 9 agreement with you. The landowner says, no, I'm not at all happy with that, and I'm going to take steps to prevent that happening. Again, we'll come to this either by taking steps directly against the mobile operator or by seeking an order against the tenant, saying it's in breach of the terms of the tenancy, forfeiting the tenancy, or seeking a mandatory injunction against it, joining in the and perhaps joining in the mobile phone operator on the basis of procuring breach or conspiracy.
But why would the operator who's been given the code right, why has he got any concern whether the landowner is bound or not? I mean, if the tenant has given the right, in what circumstances could there be any action by the landowner against the operator?
Well, because the landowner may have a right of removal. We'll come to this, but paragraph 37 sets out the circumstances in which a landowner has a right to require ECA to be removed. And if the right was granted, for example, in breach of covenant, or if the tenant is not in occupation, the landowner has got a right to require removal. And to say there may also be other routes. The landowner could, in the example I've given, where it's a breach of the terms of the tenancy, forfeit the tenancy, so therefore the operator will know that its right is precarious, and then the landowner has a direct right. It is then the person in occupation, but there hasn't been an agreement with it, nor would the landowner in those circumstances be a successor of the occupier so as to be bound within the provisions of paragraph 10. And I say the alternative is, there are cases called Hemingway and Dunraven, another one called Crestfort and Tesco, about situations, the typical case is an unlawful subletting, where the landlord has a direct action against the unlawful underlessee on the basis of conspiracy or procuring breach. So there would at least be that argument there.
So does it work in this way that, I mean, the landlord, subject to what happens under paragraph 10.4, isn't bound by the code rights? They have their rights under the tenancy agreement vis-a-vis the tenant. If the tenant breaches the tenancy, subject to the landlord being made subject to the code rights, it just exercises its ordinary rights as landowner against its tenant and says, go.
Absolutely. Lord, absolutely. So that's why there's a concern to make sure, and the code anticipates this in paragraph 10.4, that although it's the occupier granting the rights, that the operator would want, or may at least want, to make the landowner bound as well, if the occupier is not the freehold owner of the property.
And presumably you also get issues of rights of access and so on across
yes, indeed.
the main landowner's land. And
yes, indeed, yes. One can think of examples where because typically here, as you know, there are various different examples, but one example is one has got a closed compound with a fence around it, but there'll also be an access route to it as well, which will go over the landlord's land, and the landowner might say, well, look, I'm not letting you, the mobile operator, through my gate. So there are all sorts of examples like that.
But as I understand it, although it uses the language of agreement, the statute, you can just turn up as an operator and say, I like the look of that bit of land. I'd like to apply for an order, please, imposing an agreement.
Yes.
And provided those two conditions are satisfied, then you can put up your mast there or whatever it is.
Provided those two conditions are satisfied, and provided that the court exercises its discretion in your favour, and yes, that you've served the preliminary notice beforehand under paragraph 22, you can do that. Obviously, it's cheap. As your lordships can imagine, there are thousands and thousands and thousands of these sites. The costs involved in the operator's business in doing this are enormous. And so what they want to make sure is that they're doing things in the cheapest and most cost-effective way. And obviously, if they can reach an agreement, they'll want to do that. And one of the questions behind this appeal is, what do they need to do? If my learned friend Mr. Pymont's right, in certain circumstances, to get rights, they've got to remove all their apparatus off the land, then make an application, then succeed and move it back on again. We say that can't be right.
just on the question of the discretion, and I'm not sure this is going to affect things very much, but it's going to be quite a constrained discretion, isn't it? Because you've got the two conditions which would seem to address the main things that one would be interested in, balancing the public interest against the private, and you have the overall purpose of the code, which is to facilitate the rollout of electronic communication. So I would have thought, and I can see that it is a discretion, but there's not going to be very much left for the Upper Tribunal to say, well, the conditions are satisfied. We can see that the general purpose would be of the legislation would be fulfilled by granting rights, but we're not going to do it.
Lord, I entirely agree with that in the ordinary case. Absolutely. If you've got this normal case where an operator has had no involvement with the land before, has no rights in the past, and seeks to make that application, that one would be surprised if the discretion were not exercised in its favour if the first and second condition was satisfied. There are other cases, though, where one can imagine that discretion might be refused. And again, I'm going to come to those, okay. But there are cases involved, for example, just to show you where I'm going, where the operator might have rights of renewal under Part 2 of the Landlord Tenant Act 1954. And it might be said, why don't you use those rights? If you've got a right under Part 2 of the Landlord Tenant 54 for a renewal, and you've also got a right under paragraph 20, one might need to show quite a good reason why it was appropriate to exercise that discretion under paragraph 20.
Are there planning considerations also, or are they taken care of? So if the tenant says, no, I don't want this great mast and concrete bunker just outside my kitchen window, is that something that the court takes into account here, or does there have to be some separate planning exercise?
There may well be planning requirements, as I understand it, but again, as I understand it in practice, that the approach of the Upper Tribunal to date has been that's the operator's problem. If there is a planning consideration, it needs to deal with that first. Obviously, it won't have a right to put up the mast unless any planning requirements are satisfied.
So this doesn't sort of override any planning requirements that would otherwise apply? No,
absolutely not. Absolutely, it certainly doesn't. And if they need to be satisfied, as one would expect they ordinarily would, then that's an entirely separate matter. Lords, my lady, I was going to come to paragraph 22. There are a number of provisions like paragraph 22. And the meaning and the effect of them is quite important, especially because not this provision, but other similar provisions are relied on by the Court of Appeal. So paragraph 22 provides that an agreement imposed by an order under paragraph 20 takes effect for all purposes of this code as an agreement under Part 2 between the operator and the relevant person. That is either the occupier or the person that's bound. We say that the purpose of that provision is clear and obvious. Its purpose is to ensure that the special characteristics that apply to voluntary agreements apply also to agreements made by order, they being the fact that under paragraph 10 it binds successors, under paragraph 12 it's regarded as the exercise of a statutory power, under para 14 it's not registrable, under para 16 one can't exclude the right to assign, and under para 17 that there's a right to share and upgrade. And I should also add, and we'll come to this, under part 5 that there's a continuation of the rights after the end of the contractual term. We'll come to that quite shortly. That's the purpose of paragraph 22. And if there were any doubt about the matter, can I just take you to one short paragraph in the explanatory notes to the Act. This is at page 1886 of the bundle. There's some very helpful explanatory notes, and it's note 418.
Sorry, page again, please.
Page 1886.
Thank you.
And this says, para 22, like para 5.7 of the existing code, provides the court's order takes effect as an agreement under Part 2 of the code. This means any provisions applicable to an agreement reached in accordance with Part 2 of the code will apply to an agreement imposed by the courts in the same way as they apply to an agreement reached without the court's intervention. For example, the right to assign or to upgrade and share set out in paragraphs 16 and 17 will apply to a court-imposed agreement as if they had been reached under Part 2 of the code. That's all I wanted to say about paragraph 22 at the moment, and then I'm going back to the code itself.
Sorry, just before we move on from paragraph 22, I suppose it might be said that that supports what you were telling us about paragraph 20 sub 1, that A marries up with paragraph 9 and B marries up with paragraph 10. 4. Yes. It would make it hang together in a sensible way.
Lord, yes, in my submission, it does make it hang together. I should say, on this point, I'm with Mr. Pymont and I'm not with Mr. Siegler.
Yeah, I was just trying to keep track of that.
Appreciate, so I'm, yeah.
You're not with Mr. Siegler unless he succeeds.
unless he succeeds, in which case everything I've said so far, please ignore. Because I'm rooting for him, if necessary. We can deal with the other provisions of Part 4 quite quickly. Paragraph 23 sets out the terms. An order can be made imposing an agreement which gives effect to the code rights sought with such modifications as the court thinks appropriate. It sets out things that it must contain, things that it may take into account. It must, at the top of page 1823, it must include terms as to the payment of consideration. And 5, it must include terms to ensure least possible loss and damage caused to various people. 7, it must set out how long the code rights to be exercisable for. And then 24 sets out how the consideration is to be calculated. I can take this very shortly. It's basically a market value determination with one important adjustment. And the adjustment comes in 24.3a, that the market value must be assessed on the assumption that the right that the transaction relates to does not relate to the provision or use of ECA. So it's a very significant assumption in favour of an operator. It wasn't in the Law Commission report, but when it got to Parliament, they decided to put that point in. And then Para 25 deals with compensation as a result of the exerciser, and there can be provisions about that. Paragraph 26, interim... Lady, yes.
So how does this usually work then in practice? If the court makes an order, and there must be lots of these orders, is there the complete agreement attached to the order, or is it? Yes, so that's how it works. This is what's going to be the agreement. So the parties have to have worked out what the consideration is, what the compensation is, how long it's going to last. That's all sorted, and then that's the agreement that's imposed.
Absolutely. It's a little bit, a little bit like what one might do on an application under Part 2 of the Land on Tenant Act 1954, which there's some similarities. There'll be an argument about certain terms. How long's the term? Should there be a break clause? What's the rent going to be? Maybe one or two of the other terms, but there will be a travelling draft, and the tribunal will decide what the form of the agreement will be. Yeah.
And, it has to be like that, doesn't it? Because the tribunal is imposing an agreement.
Indeed.
So you need to know all the terms that it's imposed as the agreement.
Lord, yes, absolutely. Yes. So, 26 interim code rights, I'm going to come back to, if I may. It's very important for the purpose of my argument. 27 temporary code rights, I'm going to come back to that as well. But at the moment, I'm concentrating on the structure. We don't need to worry about paragraph 4a, because it deals with particular special circumstances that nobody is relying on here. And we can go straight to part 5, which starts on page 1833. Now, this paragraph 29.1 says this part of this code applies to an agreement under Part 2. It will, of course, also apply to an agreement imposed under Part 4 because of paragraph 22 that we've just been looking at. And then paragraph 31 says that if a code right is conferred by or otherwise binding on a person, we then got a new definition, the site provider, as a result of the code agreement, and under the terms of the agreement, the right ceases to be exercisable, or the site provider ceases to be bound by it, or the site provider may bring the code agreement to an end so far as it relates to that right, and it then provides in 2 that where this subparagraph applies, the code agreement continues, so that the operator may continue to exercise the right and the site provider continues to be bound by the right. And we see just over the page before I come back to it that doesn't apply to rights under para 26 and 27 that I'll come back to. So the basic position here is, notwithstanding that the contract comes to an end, either because it's determined under its terms or because it simply runs out, despite that, the code agreement continues. And as one would expect, Part 5 then goes on to deal with, notwithstanding its continuation, how can it be brought to an end or how can it be altered? And there are 2 relevant provisions in respect to that, paragraph 31 and 33. Paragraph 31 is the right for the site provider only to bring it to an end. And it can do so 18 months' notice, but only on one of a number of specified grounds set out in 31(4). That is, substantial breaches by the operator, persistent delays in making payments by the operator, C, that the site provider intends to redevelop all or part of the land, or 4, that the test under para 21 is not met. You recall that's the test about that you need to get through in order for rights to be imposed under paragraph 20. Those are the only circumstances in which the site provider has a right to bring it to an end.
So sorry, that last bit is contemplating some shift in circumstances so that the balance between the private and the public interest changes, or the compensation is no longer sufficient.
Yes.
Okay.
Lord, yes. And one can imagine there may be circumstances in which that happened, that the land changes its use, surrounding land or whatever. And if that happens, notice has to be served, which has to give at least 18 months' notice, which cannot expire before the time at which it would have come to an end otherwise. So if you've got a 5-year agreement, you can't bring it to an end earlier than 5 years under 31. You can serve notice 18 months before the end of the 5-year period, and then the operator can serve a counter notice, and the operator within 3 months, this is 32(1), of receiving that, and then within 3 months thereafter, the operator has to apply to the court for an order. If it doesn't do so, the code agreement comes to an end. And the counter notice by the operator has to state, this is over the page 1835, that the operator doesn't want the code agreement to end, and it wants the site provider to agree to confer or to be bound by a new code right. And 32(4) provides that if the court decides that the site provider has established any of the grounds, then it must order the code agreement comes to an end. It has no discretion on the matter if any of the grounds in 31(4) are established. But otherwise, it has to make one of the orders in paragraph 34. Just before we come to those, paragraph 33 provides another right to require changes to the agreement, which can be initiated by either the operator or the site provider. This is 33(1). This operator or a site provider who's party to a code agreement by which a code right is conferred may, by notice, in accordance with the paragraph, require the other party to agree: A, the code agreement should have effect with modified terms; B, it should no longer provide for an existing code right. C, it should confer an additional right. Or D, that the existing agreement should be terminated, and presumably it means, and if required, a new agreement should have effect.
Well, that's an important question that I was wondering. So you say that that is how the operator can bring the agreement to a close if they want to after the fixed term.
Lady, it's a point that we've...
way, isn't it?
Yeah, Lord, Lady, it is a point that we've puzzled at, actually. Obviously, one can't see a problem necessarily in a consensual termination. But if one has a code agreement for 5 years, which is then, we know, automatically continued under paragraph 30, and the landowner quite likes the fact he's getting £5,000 a year for this mast, but the operator no longer needs a mast there at all for whatever reason, how on earth can the operator bring it to an end? And what we would suggest, because there doesn't seem to be any provision in there, is that one needs to interpolate some words into 33(1)(d) that say the existing agreement should be terminated and, if required, we would suggest, a new agreement should have effect. We'll also, as we'll see in a moment, need to interpolate similar words into 34 if they were to have that effect. But it seems to me there must be that right. And one can search in vain to look at paragraph 30 to say, well, look, how can the continuation be brought to an end? And it's not easy to see how else it can be done. There may be various other suggestions, but that looks like the most likely one. What then? So in order to do that, 6 months' notice has to be given. This is 33(3), which again can't expire before the time at which the code agreement would have expired, but for the continuation rights under paragraph 30. That's what 3B, sub 3B says. And then the operator and the site provider may reach agreement after service of a notice, and 33(4) contemplates that. It says, if after the end of the period of 6 months beginning the date in which the notice is given, the operator and the site provider have not reached agreement, only then does subparagraph 5 apply. And subparagraph 5 says that an application can be made to the court for an order under paragraph 34. So it's an important point that the court only has jurisdiction to make an order if the operator and the site provider don't agree on the proposals. The orders that the court can then make under paragraph 34 mirror the proposals that can be put forward in paragraph 33(1). So they provide that in sub 2, 34(2), that they can simply order that the operator can continue to exercise the existing code rights, or in 2, sub 3 can order modification relating to existing right, 4 that it no longer provides for existing right, 5 that it provides for an additional code right, or 6, and again I think some interpolation is required, the court may order the termination of the code agreement relating to the existing code right, and if thought fit, I would suggest, order the operator and the site provider to enter into a new agreement. Now, again, we have a deeming provision, a little like paragraph 22 in 34(8). And it says, this code applies to the new agreement as if it were an agreement under Part 2. The new agreement is the one referred to in the previous subparagraph 7, which is the one referred to in subparagraph 6. In other words, it's if the court orders the termination of existing code agreement and it to be replaced by a new agreement, that agreement takes effect as if it were an agreement under Part 2, the reason for that, we say, is for the same reasons as paragraph 22, to bring in what I call the special characteristics of code rights. It is not to deem the site provider to be the occupier of the land, because that's not necessary for an order under Part 5. Part 5 applies, going back to paragraph 30 sub 1, where a code right is conferred by or is otherwise binding on a person, the site provider. And the order that is made in paragraph 34 is an order against the site provider. So the suggestion that there has been by the Court of Appeal that the purpose of 34.8 is to deem the agreement imposed as being imposed on the occupier of the land, we respectfully submit is not right.
And I'm so sorry, can you give us the paragraph number for the Court of Appeal? If you can't, don't worry. Just so we
I've not got it completely at my fingertips.
Right, don't worry about it, we can find it.
I'm so sorry, but I think I'll probably pick it up as I go. Sorry, it's incredibly annoying not to have a reference to hand. Yes, it. No. Yes, it is in the Compton case, paragraph 63, which is page 222 of the bundle, and in the Ashlock case, it is paragraph 41, which is page 740 of the bundle, both in the Court of Appeal judgments.
Thank you very much.
I'm sorry that took me so long to get there. So that's Part 5.
Just while we're on these provisions under Part 5, there's nothing that would allow an existing occupier, who's also an operator, to enter into an agreement for new code rights during the period that they're already occupying the land for.
Lord, it is absolutely right that Part 5 does not provide that. And the reason Part 5 doesn't provide that is Part 5 only says what you can do at the end of the contractual term.
Yeah.
So, your Lordship will recall, paragraph 31 was a right of termination, but not before the end of the contractual term. Paragraph 33, a right to change, including additional code rights, only post the end of the contractual term. It's one of the points I'm going to make and I'm going to come to shortly. The Court of Appeal were of the view, and we respectfully agree, that the parties can agree during the term to add on further code rights. And we say they should also have that right by compulsion under paragraph 20. If they don't, it can lead to all sorts of problems. Technology changes unforeseeably. The code agreement is still carrying on. They can't install their 5G mast or whatever. But I'll come to that in a bit more detail. But Your Lordship is absolutely...
Well, that would be an upgrade, though, wouldn't it? And they have the right to that. But I think the point that my Lord Borough's making is if you don't have an agreement covering all the possible rights at the outset, how can you add a new right?
Well, there are... both situations apply. Later, to deal with your Ladyship's point, the right to upgrade under paragraph 17 is a limited right, because it's circumscribed by a couple of conditions. If you don't satisfy those conditions, you haven't got that right to upgrade, which is why it's very common for operators to seek wider rights to upgrade than the minimum rights set out in paragraph 17. If either for that reason, or to take Lord Burroughs' point that one simply didn't have a code right, or one needed a right to go and lop trees, for example, and one hadn't included that at the outset, and those trees were interfering with the operation of the mast in some way, then one would want to be able to do that during the term. Be very important to do that during term. The fact that one can't do either of those things during the term is something that causes very real practical problems to the operator. If the Court of Appeal is right in Compton and in Ashloch, then there would be, although apparently there's a right to do so by agreement, but as I'll illustrate later, it's difficult to see how you square that with the reasoning in Compton and Ashloch. But in any event, it would seem clear from the reasoning in Compton and Ashloch that one could not seek an order under paragraph 20 for those rights during the term.
How could you even go on the paragraph 9?
Well, look, that's my point. Although the Court of Appeal said that this is Ashloch, again, I don't think we need to look at it, paragraph 68 in Ashloch, which is page 744, they said you could do it by agreement, relying, I think, on the provisions about variation. The grant of that code right by agreement would be effective only to confer a code right with all its special characteristics if it was conferred under paragraph 9. And if the Court of Appeal are right and the operator is in occupation, then that can't work. Except that it might work in some cases because, again, although we're spending most of the time talking about operators with ECA on land who are in occupation, not all operators will be in occupation. If you've got some aerials in the roof of Paddington Station used to get a mobile signal for all the train passengers, the operator's not going to be in occupation of the roof. But it might be in the other case where you've got a greenfield site, you've got a fence around it, and you've got a concrete plinth, at least in respect of that bit, albeit not the access routes to it. But again, I will come to that. So, yes, on the Court of Appeal's reasoning, there are real difficulties. Well, it follows directly from the Court of Appeal's reasoning that one could not get additional rights by order during the term. And we say it necessarily follows from that reasoning that one couldn't do so by agreement either. Lord and Lady, I was about to move on very briefly to part 6 of the code, 1838. I want to deal with this really quite quickly at this stage, and I'll come back to some of the details of it later. So it deals with, it's headed rights to require removal of ECA. And it says that, again, we've got a new definition of landowner here. A person with an interest in land, a landowner, has a right to require the removal of ECA if and only if one of the following conditions are met. One, landowner's never been bound. And secondly, although it was bound, that's come to an end or ceased to bind the landowner in various circumstances. And then I'm going to come back to that later, and also to 37.4, which is an important part of my argument later. Paragraph 38 we don't need to be concerned about. That's about rights of owners or occupiers of neighbouring land to get it removed. Now, if there is the right of removal, how is that to be enforced? The answer to that is in paragraph 40, which says the right of a landowner or occupier, that's a reference to the neighbouring land, to require the removal of ECA is exercisable only in accordance with this paragraph. The landowner gives notice, sub 2, paragraph 5, 28 days If no agreement is reached, then the landowner or occupier in 6 can make an application to the court for an order for removal, and then I will come back to 40 sub 8 that the court can't make an order in particular circumstances. So, Lord and Lady, that is a whirlwind tour of the main aspects of the code. And really the important points to have in mind is Part 2, voluntary agreement, the special characteristics mostly under Part 3, the right to confer an agreement or make an agreement be bounding by order under Part 4, and the rights of renewal and termination and change under Part 5. Now, we say that there are in a number of places, it is clear from the code itself that Parliament contemplated that an operator with ECA on land is not to be treated as an occupier of the land. And there are a number of different indications of that coming from the code itself. And what I was proposing to do was to go through those in turn. And the first is paragraph 26 at 1824. And this is in part 4, and you'll recall that I skated over 26 and 27 and said I would come back to it. So 26...
So can I just get clear the main submission you're putting forward? You're saying that it's never the case at anywhere in the code that an occupier with ECA is regarded, an operator with ECA is regarded as an occupier?
Yeah. I'm saying that an operator with ECA on the land is never to be regarded as the occupier of the land for the purposes of paragraph 9 or by inference paragraph 20, by application paragraph 20.
Or anywhere else in the
or anywhere else. Yeah. Yeah, I'm not suggesting that the phrase the occupier of the land means something in one part of the code and something different in another part of the code. It means the same thing in the whole of the code. Put the point another way, it was not contemplated that an operator on land with ECA there would be regarded as the occupier of the land so as to disentitle the landowner, putting it broadly, to be able to confer rights either by agreement under paragraph 9 or by order under paragraph 20. And I say that there are questions of policy that arise as well, but what I'm trying to do is to concentrate on the words of the code itself, because in my submission, your lordships are going to be most assisted by looking directly at the code rather than simply looking at the Law Commission report and explanatory notes and matters like that. But there are points in there that make it quite clear that isn't so. And the very first one is paragraph 26 and 27.
Your case is that, could you put your case this way, that whether or not the operator is the occupier of the land has to be determined leaving out of account the installation of the ECA on the land?
Yes.
You're not saying that in all circumstances this decrees that he's not the occupier, even if he would be the occupier, ignoring the influence of the ECA on that question?
It's primarily about that, but I need to go one step beyond that. I need to say, firstly, that the mere fact that the operator has ECA, that, if you like, the ECA that the operator has on the land is to be ignored. So my lady, I entirely agree with that first point. I need to go further than that for this reason, that very often code agreements will take the form of leases. Now, if we were looking at this as property lawyers, we would take the view that the tenant under the lease is going to be the occupier. But we say that's not the way to look at it here for a number of reasons. Firstly, the question of occupier is not to be determined in the way that a property lawyer would look at it. It's a little bit like, by analogy only, the case of Rossendale Borough Council and Her School Properties that my Lords Lord Hodge and Lord Leggett were in the end of, gave judgment in the end of last year, which considered not the meaning of occupier, but the meaning of owners in a rating statute. And your Lordship said that the property law interpretation of that was not to be applied. It's quite clear from a property law point of view what owners meant, but that was not to be applied here. And instead, one needed to apply a purpose of interpretation looking at the meaning of the statute. And I say that reasoning applies in precisely the same way here. So we say two strands of the argument. Firstly is applying that purpose of interpretation, even if the operator has a lease of land and would be regarded in a property sense as an occupier, it's not the occupier of the land for the meaning of the code. Occupier is a word that means different things in different contexts. Sometimes it includes squatters, sometimes it doesn't include squatters, for example. Sometimes it requires a right of control, sometimes it doesn't require a right of control. The other thing we rely on is the anti-avoidance provisions in paragraph 100. So if one imagines a case where the operator is going to put some ECA on land, which even in a property sense wouldn't be regarded as giving it a right of occupation. And the landowner says, you know what I'm going to do here? I'm going to grant them a lease so that they can't make any applications under paragraph 20 in order to limit their rights in the future. If it was done for that purpose, it would be contrary to the anti-avoidance provisions under paragraph 100. If not, and then it does, the extension from that is it doesn't matter whether it was done subjectively for that reason. If it has that effect, that it takes operators out of the code, then it would be contrary to the anti-avoidance provisions. So there's a couple of different ways of looking at it. The admittedly more difficult case where one has a lease. Lady, I hope that was,
yes,
that was
you've answered my
at least half helpful. So I want to take your Lordships to a number of provisions. I'll try and do it as speedily and economically as I can. The first is paragraph 26. This is about the grant of interim rights. So it's about the grant of rights to an operator who wants them on an interim basis before getting full rights normally. And it says in paragraph 26.1, page 1824, an operator may apply to the court for an order which imposes on the operator and the person on an interim basis an agreement between them which confers the code rights or provides for a code right to bind. Subparagraph 2 over the page, an order imposing agreement on an interim basis has to provide for them to be bound for the period specified in the order or until the occurrence of an event specified in the order. And then sub 3, the court may make an order under this paragraph if and only if the operator has given the person mentioned a notice which complies with paragraph 22, stating that agreement is sought on an interim basis. And you'll see under B, the test is good arguable case that the test in paragraph 21 is satisfied. And then I'll come back to 4, but 7 provides that subparagraph 8 applies if B, the period specified has expired or the event has occurred without an agreement relating to the code right having been imposed by order under paragraph 20. And then the person has the right to require removal under part 6. And we look briefly at part 6, And I think I also mentioned that the continuation rights under Part 5 don't apply to interim rights. That was paragraph 33. So it's clear from paragraph 26(7)(b) at the bottom of page 1825 that the primary purpose of an application for interim rights is that it provides rights for a period to be followed by an application for the grant of full rights. On the basis you've only got to satisfy the good arguable case test initially, and then there will come on an application for full rights. And indeed, this may all happen very, very urgently. I made such an application, I think, during the long vacation last year, and had quite a job finding a judge, actually. But it says in subparagraph 5 it could be done as a matter of urgency. So,
well, this is because, for example, somebody in relation to whom you haven't established a code right is causing some problem to the operation of the...
Yes, absolutely. In the case I did, I think it was over last summer, there was a fire at one mast and it was destroyed. And we very, very quickly, the operator, needed to get another mast up nearby in order to keep the mobile services going for the emergency services, for example, as well as, no doubt, people using social media and whatever. But that had to be done very quickly, and therefore an application was made under paragraph 26.
So an application to put up a new mast on a different site?
On a different site, in a different site. Now, the important and obvious point here is that if an application for interim rights is granted under paragraph 26, and if that results in the operator going into occupation and being treated as the occupier of the land, there cannot be a grant of rights under paragraph 20. Yet, Parliament clearly envisages that there can be that. Now, it's clear that that is the purpose of paragraph 26. If, my lords, my lady, you would go to the explanatory notes again, page 1887, and it's explanatory note 422.
Page number again?
Page 1887, my lady. This states that paragraph 26 provides an operator can apply for interim code rights. This enabled code rights to be granted on an interim basis pending the parties reach agreement or the court imposing a final agreement. Granted on interim basis where the parties agree to making of an order, or B, when the court considers the good arguable case, interim code rights will be made permanent at a final hearing. That cannot happen if the Court of Appeal are correct. Now, in the Compton case, I'm not going to take your lordships to it, it's paragraph 73 to 74 of the judgment in the Compton Court of Appeal, page 223. The Court of Appeal said the solution to this conundrum was paragraph 26(4)(b), which is back on page 1825. We say that is not a solution. So that says that the following provisions apply in relation to an order under this paragraph and an agreement imposed by it as they apply in relation to an order under paragraph 20 and in an agreement imposed by it. B, para 22. It's a provision we looked at before, which has the effect that the special characteristics of code rights, assignment, upgrading, sharing, non-registration, etc., apply to interim code rights that are granted by order. But it doesn't solve the problem that if, as a result of the grant of interim code rights, the operator is an occupation, how is it granted rights under paragraph 20? 26(4)(b) doesn't do that. 26(4)(b) is about the characteristics of interim code rights. And if what is said, oh, well, paragraph 22 does that itself, then we have a situation, and maybe the learned friend Mr. Seatler relies on this, I'm not sure, is that we then have a situation where paragraph 20 order can be made against someone who's not the occupier of the land. Now, we don't say that was the purpose of paragraph 22 at all. It's simply to bring in the special characteristics. So 26(4)(b) doesn't solve the problem. My learned friend Mr. Pymont suggests a different point. He points out that in a case called Cornerstone and University of London, I'm not going to ask your lordships to go to it, but it's page 2311 in the bundle. That held, the Court of Appeal held, that a paragraph 26 application can stand alone without a paragraph 20 application to follow. But it also said that the primary purpose of a paragraph 26 application was to be followed by a paragraph 20 application, albeit there might be circumstances where you didn't need to go on and then make a paragraph 20 application. So your
point is that the very making of the interim application, if successful, frustrates the final application.
Lord, yes. Yeah. It's as simple as that. So, Lord, that's all I wanted to say about paragraph 26. It doesn't work if the Court of Appeal are right. Neither does paragraph 27. And this is perhaps an even stronger point. A paragraph 26 application does not need to be combined, although it usually will, does not need to be combined with a paragraph 20 application. But a paragraph 27 application does need to be. Paragraph 27 is at page 1826. Paragraph 27 deals with, if you like, the opposite end of the problem. Paragraph 26 is dealing with the situation of an operator wanting to go onto the site. Paragraph 27 is dealing with an operator who is on the site, where a person has got a right to remove it, and it wants temporary rights pending the application for full rights under paragraph 20. So it states, 27(1), this paragraph applies where an operator gives notice under paragraph 20 sub 2, so that's your paragraph 20 application. That notice, the paragraph 20 notice, also requires a person's agreement on a temporary basis in respect of a right which is to be exercisable in whole or part in relation to ECA, which is already installed on, under, or over the land. And indeed, there are regulations saying that the paragraph 27 has to be in the paragraph 20 notice itself. And then C, that the person has a right to require the removal under paragraph 37, but the operator is not for the time being required to remove it. That is, no order has yet been made under, I forget whether it's paragraph 43 or 44. And then the court may, on an application of the operator, impose on the operator and the person an agreement between them which confers on the operator, paragraph 9, or provides for the person to be bound by, paragraph 10(4), such temporary code rights as appear to the court reasonably necessary for securing the objective in sub 3. And sub 3 says the objective is that until the proceedings under paragraph 20 are determined, the service provided by the operator's network is maintained and the apparatus is properly adjusted and kept in repair. Now, there is also in paragraph 27 a deeming provision, 27(4)(b), which is precisely the same as the one in 26(4)(b). And your lordships know what I'm going to say about that, which is it's about the characteristics of the temporary right granted under paragraph 27. It's nothing to do with the rights granted under paragraph 20 and doesn't get away from the words the occupier of the land as required under paragraph 20 because of paragraph 9.
But if the person has already got the ECA installed on the land, why are they having to give a notice under paragraph 22 to a person for acquiring a code right?
Para 27 deals with the situation where an operator has got ECA on land, but it doesn't have any rights for that ECA. So its rights have come to an end in some way. They've been terminated, for example, under paragraph 32, if it had continuation rights under paragraph 30, or it didn't have any rights in the first place. It put the ECA on there without permission, would be a second example. But for whatever reason, the various different situations, it might have sought, it or the site provider might have sought a change in the terms of the agreement under paragraph 33, under part 5, after the end of the code agreement, and the tribunal might have refused to grant it. For whatever reason, there is no right to have the ECA there, but it is there. And if the Court of Appeal is right, physical control is all that matters, even without a right of control. And then there's a right to seek temporary rights in respect of ECA that's already there, pending an application for full rights. Now, the Court of Appeal thought that 27(4)(b) solved the conundrum, but it doesn't for precisely the same reasons that 26(4)(b) doesn't solve the conundrum. The other solution that was posited by the Court of Appeal, and this is paragraph 65 in Ashlock, which is page 744, again, I'm not suggesting that we go to it, is that one relied on paragraph 27(8) that I haven't yet taken your Lordships to. And if one reads it in isolation, it looks a bit promising. It says, the court must, in determining for the purposes of paragraph 20 whether the apparatus should continue to be kept on, under, or over the land, disregard the fact the apparatus has already been installed there. However, subparagraph 8 only applies where subparagraph 7 applies. And subparagraph 7 applies only where, in the course of proceedings under paragraph 20, it's shown that a person with an interest in land was entitled to require the removal of the apparatus immediately after it was installed. So it would apply in a case where the operator in the middle of the night put the ECA on there without anyone's permission at all. But it wouldn't apply if it sought permission of the occupier who said, sure, you can have that permission for a period, and then that right had expired. So subparagraph 8 doesn't solve the problem. Also, that's not the purpose of subparagraph 8. The purpose of subparagraph 8 is to prevent the operator stealing a marge by saying, well, look, it's already there. It would be the most terrible thing if I now had to remove it. It would be a most terrible waste, in order to try and help it get through the test in paragraph 21, or the exercise of the discretion under paragraph 21. And there's a reference, again, I won't take your Lordships to it because I'm conscious and slightly anxious about the time, that there's an excerpt from Hansard at page 3334 of the bundle, which describes the purpose of the provision in 27(8 and says, indeed, it's about stealing a marge. It doesn't use those words, but that's the effect of what it says. We say, therefore, that it's clear that that causes a problem. Learned Friend says, as I understand it, is, oh, well, that's not really what paragraph 27 is about. It's not about the conferral of rights. So you don't need to worry about the occupier of the land point. It's really about making the owner of a superior interest who's not bound, bound. It's about making other people bound rather than for conferring rights. The problem with that is paragraph 27(2) makes it quite clear, it's the second line, and impose on the operator and the person an agreement between them which either confers rights on the operator or provides for the person to be bound. It's dealing with both possibilities. So it is not limited to cases about making people bound. So paragraph 27 is the second provision that we rely on. The third provision we rely on is paragraph 40, subparagraph 8, which is at page 1840. Well, we can start from 1841, is paragraph 40. And those of us will recall, we've looked briefly at this. And this is the provision that enables the landowner to get an order requiring the removal of ECA from the land. And it says the right of a landowner to require the removal of ECA on or under land under paragraphs 37, no need to worry about 38, is exercisable only in accordance with this paragraph. Notice has to be given, application made to the court can then make an order. And then subparagraph 8 says that the court can't make an order in relation to the ECA if an application under paragraph 23 has been made in relation to the ECA and hasn't been determined. So it's dealing with the situation where the operator has ECA on the land that may result in it being an occupation. And an answer to that is that an application can be made under paragraph 20. Now, the view of the Court of Appeal in Ashlock, this is paragraph 78 of Ashlock, page 747 of the bundle, again I'm not suggesting your lordships go to it, is that in the circumstances there won't be any right to make an application under paragraph 20 if the operator has got ECA on the land. Because if you imagine a case that's within Part 5, and if the site provider has served a notice under paragraph 31, and either there's no counter notice or the court's made an order terminating existing rights, in those circumstances it's suggested that the operator can't make an application under paragraph 20. However, it can. And we can see clearly that it can, because paragraph 40 sub 1 applies where there's a right of the landowner to require the removal of ECA under paragraph 37. If one goes back to paragraph 37(3), so this is page 1838, one of the circumstances which that right can occur under paragraph 37 is the second condition, that the code right entitling an operator to keep the ECA has come to an end or ceased to bind the landowner. And one of the ways that can happen is under C, as a result of an order under para 32(4) or 34(4) or 6, where an order under 32(4) is an order terminating the code rights after notice by the site provider under para 31, and 34(4) or 6 is after a notice under paragraph 33 by either the site provider or the operator. The court determines that the code agreement should no longer provide for an existing code right or should be terminated. So it is quite clear, and I take this point, if you like, on the chin, that notwithstanding that a operator may have failed to protect its interest under the provisions of Part 5, it still has a second chance to keep the ECA on the land. Notwithstanding that it might have failed to take those steps, it still has a right. There's then a right of removal, but in order to enforce that right of removal, it's a defence that there's a paragraph 20 application. Now, two things I would say about that. Firstly, one can imagine cases where part of the ECA might interfere with the redevelopment intended by the landowner. If that's so, then the mandatory ground for termination under 31(4)(c) would be established. The operator might apply, of course, for a modified form of agreement in respect to the rest of the land. Let's assume it fails to do so. It has a further chance to apply under paragraph 20. Now, it's important for this part of the argument, or it's important to make sense of it, that the discretion that I emphasised applies under paragraph 20 is a real discretion. Because one can see circumstances in which the site provider has no good reason for not applying before now, that it should not be granted a right under paragraph 20. Or if it's got no different points that it wants to raise than the points that it did raise under its application for an order under paragraph 34, then one would expect the tribunal swiftly to dismiss the paragraph 20 application. But because Parliament felt it was so important that the apparatus was available for the benefit of the public, even if the operator has not taken steps to protect, it has a last chance saloon in paragraph 40 sub 8. That provision, 40 sub 8, cannot work if the Court of Appeal's reasoning is right in a case where the operator has control of the land sufficient to make it the occupier in any other sense. So, Lord, those are the three important provisions. The others I can go through much more quickly. There's one quite technical but very important one, which is paragraph 37. Starts at page 1838. We've looked at aspects of this. This is the right of the landowner to require removal. And it's subject to a couple of conditions, either that the landowner has never been bound or that it ceased to bind the landowner. And that's got an important qualification in 37 sub 4 at page 1839. So the landowner does not meet the first or second condition and therefore does not have a right of removal if the land is occupied by a person who conferred a code right entitling an operator to keep the apparatus on the land, or is otherwise bound by such a right, and that code right was not conferred in breach of covenant enforceable by the landowner. So if we imagine, first of all, a case where the result of putting the ECA on the land is not to make the operator the occupier of the land, and we have a landowner and we have got a tenant who conferred rights on the operator, provided that that tenancy is continuing, and provided that the code right that the grant of the code right by the tenant to the operator was not in breach of covenant in the tenant's lease, then the landowner does not have that right. And that's obviously a really important protection. In those circumstances, in reality, there is no need for the operator to get an order making the landowner bound, because the tenant had rights, it granted those, and that's fine, and the landowner has no right of removal. But if the result of the grant of code rights is to treat the land as being occupied by the operator, in those circumstances, the operator doesn't have that protection. Now, maybe the answer is, well, has that protection in some circumstances, but not in other circumstances. But why should it depend on that? So assume a case where the tenant, as it's entitled to under the terms of its tenancy, has granted the operator a right to put ECA on the land, which and the operator constructs a closed compound with a fence all round it and is to be treated as in occupation. In those circumstances, the landowner has a right of removal. It's perhaps a 999-year lease. It's got a right of removal. It's not in breach of the terms of the lease. But different if it's not a closed compound, but some aerials on the roof of Paddington Station. In those circumstances, the train operator, or whoever it is the person in occupation of the station, and the landowner doesn't have the right. And that, we submit, would be a very odd conclusion. The next category I wanted to come on to, which I've already dealt with very, very briefly in much earlier discussion with my Lord Burrows, is the question of additional rights during the term. This is a real practical problem for operators, as I've emphasised. Can I give your Lordships the reference rather than taking you to it? You've got the number of reports. One is by the Department of Culture, Media and Sport in January last year, paragraph 2.37 of that, page 3225 of the bundle, refers to that real concern for operators that they can't get increased rights during the term. Now, Ashloch, in the Court of Appeal, paragraph 68, says there's no problem in doing that by agreement. We agree with that. If one goes back to page 1816 in the code, which is paragraph 11(2), it applies to variations of the agreement. So by agreement, you can do variations. And one would have thought, I can't see any reason why not, those variations could not include code rights. But the problem is, there would be new rights granted which would fall within paragraph 9. And the Court of Appeal don't address that problem. The question arises, can they be done by order under paragraph 20? We know they can after the end of the term if you're within part 5, but can they be done before that? The explanatory notes indicate that they can, and can I invite you Lordships to look at that, page 1896. It's page 1896, paragraph 499. And both this note and 497 were referred to in the Court of Appeal in Ashloch. So 499 says that an operator cannot be required to agree that it will forego its rights to make an application to the court under Part 4 for different or additional code rights for which it would have to pay additional consideration. For example, an operator may have an agreement with a site provider under which the operator is entitled to enter the land to maintain apparatus on terms that gives at least 72 hours notice. Operator might later wish to seek a different code agreement, e.g. to enter the land to maintain apparatus giving only 48 hours notice. That would be a new right, more onerous for the landowner, which would have to be agreed on further terms, including as to payment. Failing agreement, the operator could apply to the court for the grant of the new right. The court will be required to apply the test under para 21. So the explanatory notes are crystal clear that an application can be made during the term for additional rights. That's to be contrasted with the position in respect of variations not involving the grant of additional code rights, which are dealt with in 497. 497 says paragraph 100 concerns the binding quality of agreements, agreements for code rights are final, so that once agreed, it's not possible for either party to reopen the agreement. For example, if an operator agrees to pay £5,000 for a consensual code agreement, the operator can't then apply to get a better price or approve the accompanying terms that relate to the code rights that have been granted. Now, I entirely accept that some fine distinctions might need to be made between what is a variation and what is the grant of a code right. And I think my learned friend Mr. Seitler in the Court of Appeal in Ashlock said that he didn't think that the example in 499 was a very good example. For our part, we don't go that far. We think it is. If you've got a right to enter on 72 hours notice, a right to do it on 48 hours notice can be granted, and it's a new right. We may be right, we may be wrong on that, but there is a distinction between the grant of additional code rights and variations of existing agreements. Variations can only be done by agreement during the term. People are held to their bargains. But an additional code right granted under paragraph 20 that doesn't alter the existing bargain is something that can be done under paragraph 20. Of course, if the Court of Appeal is correct, it can't be done by order. And more importantly, if the Court of Appeal's reasoning is correct, their conclusion that it can be done by agreement is difficult to understand. So that's all I wanted to say about additional code rights.
These explanatory notes are departmental notes, not parliamentary notes, is that right?
No, these are do we know the answer? Can I come back to your Lordship?
Well, it is of some importance.
Of course, I appreciate that. I'm sorry not to have an immediate answer to that. But
well, it's not clear from the opening page, but we see the Royal Coat of Arms, but no suggestion that it's a parliamentary document.
We'll check over the shorter German. I'm sorry I don't have that at my fingertips. The next question I wanted to address was this. How does one achieve a voluntary renewal of an agreement either made by agreement under Part 2 or made by order under Part 4? And if your Lordships go to page 1833... Yeah, 1830. Yeah, well, sorry, 1833, simply to remind us in paragraph 30 that those rights continue until brought to an end. And then, if you would go on to 34, the orders that can be made. And I've got a wrong reference here. Yeah, sorry. Paragraph 33(4) is what I had in mind. I'm much better off just ignoring my notes, which is what I've done so far. So, orders. The court can make an order under paragraph 34. For example, a new agreement, see 34(6). But 34(4) provides that subparagraph 5 applies if, after the end of the period of 6 months, the operator and the site provider have not reached agreement. Subparagraph 5 then says where this paragraph applies, the site provider can apply to the court. So the effect is that the court can only make an order for a new agreement replacing an old agreement if the parties haven't reached agreement on that themselves. If they do agree with the operator's proposal or the site provider's proposal to replace the old agreement with a new agreement, then the court cannot make an order. But the question then arises, how does that agreement take effect? we submit that it can only take effect as an agreement under paragraph 9. And then, of course, one sees the problem. But, of course, if the operator is in occupation, an agreement under paragraph 9 doesn't work. Now, the solution that was suggested by the Court of Appeal is to have regard to 34 paragraph 8. But 34 paragraph 8, firstly, applies only if paragraph 34 applies. In other words, it only applies in the circumstances in which the court makes an order for a new agreement. And in any event, 34.8 is not about deeming a person to be not an occupier. So there is no answer to this really important conundrum, which is, how is an agreement reached as contemplated in paragraph 33.4, which doesn't involve an order from the court, an agreement which confers code rights, which it needs to be in order to get the special characteristics. And there's no answer to that. Now, so far, I've got two and only two further examples, Your Lordships will be very pleased to hear. So far, all the examples that I've given have got nothing to do with the transitional provisions whatsoever. And the reason I'm underlining that is one of my learned friends' objection is, well, these cases are all cases to do with the transitional provisions. And that's what this is about. And maybe they don't work very well, but there we are. Once we're out of the transitional provisions, we're fine. These three cases, it's right, on the facts, are all cases about where a party had rights before the 28th of December 2017, or didn't have rights at that date, and one needed to look at the moving from the old code to the new code. But the implication of the Court of Appeal's reasoning, in the various respects that I've mentioned so far, that's 26, 27, 40 sub 8, 37.4, additional code rights during the term, and how does one get a voluntary renewal of a Part 2 or Part 4 agreement that comes within Part 5, have nothing to do with the transitional provisions. My last two examples, I accept, do. And the first is this. Operators at the 28th of December 2017, at that stage, who have agreements that have expired and who don't have rights under Part 2 of the Land Law and Tenant Act 1954. Now, if the Court of Appeal is correct, they cannot get code rights either by agreement or by order if they are in occupation. And again, that's a significant practical problem. See the DCMS report. It's in the bundle. Again, I'm not going to ask you, Lordship, to look at it. Page 3221 to 2, and it's paragraph 2.27 to 2.30 of DCMS's 2021 report. And we say it cannot have been intended that operators who at that date had no rights should not be able to get rights either by agreement or by order under the code without one of the workarounds. The workarounds you'll have seen in the cases are either getting a grant, giving a grant to a friendly operator, or more likely moving out of the site. That can't have been intended. And I want to consider the position very briefly, both under the old code, under the transitional provisions, and then looking at the new code. So under the old code, I'm now going to invite your Lordships for the first time to look at the old code, page 1901. Sorry, do I mean that? 1902, I'm sorry. So paragraph 2 provided an agreement had to be in writing. Paragraph 3, similar provisions, again, 3.2, agreement in writing in respect of the rights specifically they're referred to. So the rights were split between paragraph 2 and paragraph 3. The only important point is they had to be in writing.
And that's why the tenancy at will doesn't amount to a subsisting agreement.
That's right, because it's not in writing, yes. Yeah, that was the problem which Judge Cook found in Ontario. Under Scots law, which I claim to be no expert whatsoever, I think the position may be a little different because of the idea of tacit relocation, which I think is going to be treated as a continuation for the period of tacit relocation of the old written agreement. But under English law, that would certainly be the position. There is then the provision in paragraph 5, page 1907, which is the equivalent of new paragraph 20, that where an operator requires any person to agree for the purpose in paragraph 2 or 3 that any rights should be conferred, then he gives notice and can make an application. And then paragraph 6 is the equivalent of paragraph 27 in relation to temporary rights. It says where the following provisions apply where the operator gives notice to any person in relation to telecommunication apparatus already kept installed and the person is entitled to require removal. Sub 2, the court may confer on the operator temporary rights. It's important perhaps just while we're at this, because it will be relevant later on to see what they are. They're temporary rights as appear reasonably necessary for securing the pending determination of the proceedings. The service provided by the system is maintained and the apparatus properly adjusted and kept in repair. And then...
That's the equivalent of paragraph 27.
Yes, indeed, lady. And then it's provided in 6.3 that in any case where it's shown that a person with interest in land was entitled to require the removal immediately after it was installed, so this is the equivalent of paragraph 27.8, the court shall disregard the fact that it's there. It's about stealing a marsh. And then there's just one, I'm only going to invite you to look at one other provision in the Old Code, which is paragraph 21, which starts at page 1920. And this, I should say, before coming to this, unlike under the new code, there's no automatic continuation under paragraph 30 under the old code. Your rights just come to an end at the end of the contractual term. And then 21.1 says, where any person is for the time being entitled to require the removal, this applies. And then sub 2, person entitled to require removal can give notice. Sub 3, a counter notice can be given. 4, the counter notice can in B specify the steps which the operator proposes to take for the purpose of securing a right as against that person to keep the apparatus on the land. And 5, and this is the point paragraph my learned friend relies on, those and steps may include any steps the operator could take for the purpose of enabling the apparatus removed to reinstall. And the fact that by reason of the following provision of this paragraph any proposed reinstallation is only hypothetical shall not prevent the operator from taking those steps or any court person from exercising any function in consequence of those steps having been taken. So it is quite clear that under the old code, if you were an operator in occupation whose rights had come to an end, that you could seek new rights under the code. Now,
even though your equipment was still installed?
Even though your equipment is still there. If necessary, you could say, well, 21.5 is what gives me the right there. Say that. So you're saying, I will apply for a right to reinstall, and the objection, well, you don't need a right to reinstall because your apparatus is already there, is not an objection that can be taken.
It's pretty convoluted, that, isn't it?
It's a pretty convoluted way of doing it, and for our part, we don't say that the purpose of that is to deem the operator not to be in occupation. It's about stealing a march again. It's about saying, when we're considering your old code paragraph 5 application, we will do so, if you like, with a blank sheet. That's the point of it. But in any event, there doesn't seem to be any doubt that under the old code, if you had rights that come to an end, you don't have to take everything off and put it back on again. Having made and succeeded in a new paragraph 5 application, you can get a renewal. But one has to reach that conclusion for it to have any common sense at all. Then can I invite you to look at the transitional provisions. We looked at the provisions under the old code. So an operator with an expired agreement without 54 Act rights under the old code had a right to seek new rights. Under the transitional provisions, can I invite you to go to 1877, which is where they start in the bundle.
Just before we leave the old code, was the basic setup about agreements between operators and occupiers in the same form as it's under the new code?
Yes.
Why weren't these problems occurring under the old code?
No one took this point. The point that found favour in the Upper Tribunal and found favour in the Court of Appeal was never taken before the Compton case. No one in all the books or anything, as far as I can see, and learned from Mr. Radley Gardner has been doing this since he was in shorts, and has never encountered this point at all. Yes. So the point was never taken, but Your Lordship is absolutely right that if one goes back to 1902, for example, the agreement in writing of the occupier for the time being of the land, and in paragraph 3.2, the agreement in writing, exactly the same words. So if there was a point, it was a point that could have been taken there as well. The transitional provisions, 1877, they start. To understand those, we need to understand the meaning of subsisting agreement, which is defined in paragraph 1.4 as an agreement for the purposes of paragraph 2 or 3 of the existing code. So it's got to be an agreement in writing or an order under paragraph 5 of the code. So if there was no subsisting agreement as at the 28th of December 2017, but a notice had been given under paragraph 5 of the old code, or an application had been made under paragraph 5 of the old code, but that application hadn't been determined, that is treated under the transitional provisions as being made under paragraph 20 of the new code. And one can see that from paragraphs 11 and 12 of the transitional provisions, page 1879. And they say simply that. And we say that's interesting because they indicate that there is at least one case where a paragraph 20, new code paragraph 20 application can succeed where the operator may be in occupation, which is where paragraph 20 applies because the transitional provisions apply because there had been notice under the old code. So under the transitional provisions, the position of an operator under an expired agreement without 54 Act rights could seek a right, and that would be a right granted under paragraph 20 of the new code. Turning to the new code, if the Court of Appeal is right, such an order cannot be made if the operator is in occupation and if no notice was given before the 28th of December 2017. It's therefore worse than the position under the old code, worse than the position under the transitional provisions. And indeed, if the Court of Appeal's reasoning is right, not only can one not do it under paragraph 20, one can't do it voluntarily either, because it wouldn't come within paragraph 9. Now, so at this point, Malone Friend seeks to rely on paragraph 21(5) of the old code, the rather convoluted provision, as my Lord Legate described it, as to which we say it was only to deal with the objection that any reinstallation was hypothetical, and so that matters be considered as a blank sheet, as the first point we make. The second point we say is, as Malone Friend says, oh, well, mission of paragraph 25 is all very, very significant. It really cannot have been intended that that omission was intended to put an operator in a worse position than it was in under the old code or under the transitional provisions. The whole point of the new code was to make it easier for operators, not to make it more difficult for operators. So that's the position of operators at 28th December 17 under expired agreements without 54 Act rights. And the final example I wanted to consider was operators at 28th of December 17 with rights under the 54 Act. Now, we first need to get a clear understanding of what applies and what doesn't apply here. Part 5 does not apply. If lordships are still in the transitional provisions, it's page 1878, paragraph 6.2. So paragraph 6.2 does not apply to a subsisting agreement. That's a lease of land if it's a lease to which part 2 of the 54 Act applies. And there's no agreement under section 30A excluding. So in the typical case, part 5 doesn't apply. But we also know that, and therefore the 54 Act continues to apply to that 54 Act protected tenancy. However, once renewed under the Act after the 28th of December 17, the 54 Act no longer applies. See page 1959, which is section 43(4) of the 54 Act, which says this part of this Act does not apply to a tenancy if the primary purpose is to grant code rights and it's granted after the schedule comes into force. And so the idea is that Part 5 doesn't apply to the position of 54 Act protected tenancies at 28th December 17, but the 54 Act does. If they're renewed under the 54 Act, then there's no further right of renewal under that Act, and the intention, therefore, was that they should be renewed under Part 5. And again, I'm not asking your lordships to look at it, but paragraph 103 in Ashlaw Court of Appeal, page 752, said that the intention was there should be a right of renewal under Part 5. But the question I ask rhetorically is, how on earth can they be renewed within Part 5? Because they can only be renewed within Part 5 if they fall within Part 2. Again, perhaps we go back to page 1833, which is paragraph 29 of the new code. And it sets out what Part 5 applies to. and says this part applies to an agreement under Part 2. But, so the question is, you've got 54 Act tenancy before the 28th of December 17. We assume it's renewed after the 28th of December 17. It's no longer within the 54 Act. Does it fall within Part 5? Well, if the Court of Appeal is right, it doesn't. Because, now I'm beginning to repeat myself, because the operator was an occupation. So it wasn't a right conferred by the person in occupation. At first instance in Ashloch, this is paragraph 108 of first instance in Ashloch, I'm not asking your lordships to look it up, page 777, said, as okay, the answer to that is paragraph 34.8. And can I remind your lordships of that again, page 1836. And that's the one that says, the new agreement ordered by the court under Part 5 takes effect as an agreement under Part 2. Well, your lordships have my submissions about that. It's nothing to do with that deemed occupation. It's about the characteristics that apply to code rights. But it doesn't work because the question we're at is whether you get into Part 5, not what orders you make under Part 5. Paragraph 34.8 applies if the Part 5 were to apply to the renewal tenancy under the 54 Act, and if it was further renewed under Part 5. But you only get into Part 5 if that tenancy under the 54 Act falls within Part 2 or Part 4, and it doesn't.
Why doesn't it?
It doesn't if, because the renewal tenancy under the 54 Act will be granted to a tenant in occupation. The tenant was in occupation. That first 54 Act tenancy will come to an end and will be replaced by a new 54 Act tenancy. If the Court of Appeal are right, then that agreement doesn't result in the conferral of code rights because it's the operator that's in occupation.
Why would the operator renew the 1954 Act tenancy after the new code comes into effect?
Well, it's likely to do so because it doesn't fall within Part 5. So it's the most obvious way. If the Court of Appeal is correct, it can only do one of two things. Either it can seek a renewal under the 54 Act. I mean, its rights may be brought to an end by a notice under Section 25 or by itself under Section 26 of the Act, of the 54 Act. So the landlord can force a situation in which the tenant will lose its rights unless it seeks a renewal under the 54 Act. If the tenant receives a notice under Section 25 of the Landlord Tenant Act 1954 from the landlord bringing it to an end, then the tenant could seek a renewal under the 54 Act. Once renewed, it would no longer be a 54 Act tenancy.
But you're sure that the tenancy continues to be a 1954 Act tenancy after the new code comes into effect, even in the presence of that provision that says it's no longer a 1954 Act tenancy?
Yes, because it only says. Sorry, I probably went through this far too fast. Can I go back to page 1959? Sorry, ladies, it's entirely my fault in gabbling through these quite complicated provisions. Page 1959. We're now. This is the Landlord Tenant Act 1954. And we're looking at section 43, subsection 4 in the middle of the page, saying this part, that is part 2 of the Landlord Tenant Act 1954, does not apply to a tenancy, the primary purpose of which is to grant code rights, and which is granted after the schedule coming into force. So what the Upper Tribunal have determined in various cases is that there is a right of renewal under the 54 Act, But once renewed within the 54 Act, the 54 Act ceases to have any further application. We know that Part 5 doesn't apply to a 54 Act protected tenancy. That was paragraph 6.2 of the transitional provisions. And one can see the sense of that. There are two different continuation provisions. So the continuation provisions under paragraph 30, and there's the continuation provisions under section 24 of the Landlord and Tenant Act 1954. It would be a bit of a mess if they were both to apply. So, not a problem under the old code because there was no continuation of code rights. Under the new code, you can see that the drafter said, well, okay, so which continuation provision applies here? We'll say that the Part 5 continuation provisions don't apply if there are already continuation rights under the 54 Act. But once you've exercised those continuation rights under the 54 Act, at that point, you don't have any, your rights under the 54 Act come to an end. That's what section 43.4 says. And the intention must have been that any further renewal, that there would be a right of further renewal under Part 5. And Ashlock, Court of Appeal, paragraph 103 says that's precisely the position. And the problem is, how can that be the case if the new tenancy granted after 28th of 17 under the 54 Act was granted, as it inevitably will be, to the person in occupation? If the tenant's not in occupation, it loses its rights under the 54 Act anyway. And the answer that's sought to put to that, which is, the answer that suggested by the Upper Tribunal in Ashlock to that, at 108, page 777, but no need to look it up, was paragraph 34.8 is the answer. What page is that? Okay, I'm there. But 34.8...
1836.
1836, my lady, I'm very grateful. But that's only dealing... Whatever 34.8 does, and you have my submission, it's only to deal with the characteristics of code rights, nothing more. But whatever its effect, it only applies to an agreement ordered under paragraph 34. You can only get an order for a new agreement under paragraph 34 if you fall within Part 5. You only fall within Part 5 if you're within paragraph 29. And you're only within paragraph 9 if you've got an agreement under Part 2 or an order conferring you an agreement under Part 4, which is treated as an agreement under Part 2. If you have a 54 Act tenancy, you are not that. So it doesn't explain, although everyone has agreed that it simply must be right that if after the 28th December 17 your 54 Act tenancy is further renewed, that at that point we know it steps out of the 54 Act, it must be right that you've got a right of renewal of it under Part 5, but not so under the Court of Appeal's reason. I'm going to come in a moment to the answer, but I just wanted to make a couple of other points that I've really made. I'll make them very, very fast, which is if the Court of Appeal is right, the application of the code is going to be arbitrary. It will depend on the type of site or operator. Is it a mobile operator with a fixed compound? Is it going to be a cable or fibre operator who's not going to be in occupation of any land at all? Is it going to be in a rural setting where a compound might be needed on the basis of safety and security, rather than a rooftop where there's no reason to have a site compound? Why should an operator be penalised just because, for reasons of safety or security or because of the type of site, it's in occupation? That's the first point. The second point is this. On the Court of Appeal's reasoning, one would distinguish, if we're imagining a case of a site compound, so that there's a small fenced area with a concrete plinth and a big mast and one or two cabinets. There'll be that, but there'll also be an easement of access from the main road across the landowner's land to it, in a typical case. On the Court of Appeal's reasoning, the site compound is in the occupation of the operator. So, as regards that, it can't seek any rights under paragraph 20, because it's an occupation of that, but it won't be an occupation of the access road or of car parking facilities and such like round and about shared with other people. It would be an odd distinction to make here. It may also depend on whether there's a lease or it's a license. And the other thing that's important to note is that, I think I've already made this point really, although we're concentrating on cases where the operator is an occupation, that won't be every case. Eaves of railway stations, for example. So it has arbitrary application. The result will be, in practice, that operators are exposed to ransom because they won't be able to seek additional rights during the term. They won't have rights of renewal under Part 5. And the reality is that they will pay site providers over the odds to get rights, notwithstanding that those rights won't be code rights. So those are the problems. We say, therefore, that it cannot, on a close reading of the code, it cannot have been the intention of the Parliament that an operator with ECA in the land was to be treated as the occupier of the land for the purposes of paragraph 9 and by extension paragraph 20. So I come to the solution. And can I start?
Just before you move on from that point that you've just made, is there anything to be said for problems that may occur if you don't? If you take the view that the occupier operator is the only person who can confer code rights. What I'm thinking is, say you had rival operators, wouldn't they then, on your interpretation, be able to make an agreement in relation to a particular site, an agreement with, let's say, the landowner, where there is already an operator? I mean, is that not a potential problem?
It's right that that's a point I need to address, my Lord, now. I was going to do so. Let me address it right now. Sometimes it's called blue-on-blue applications, as you may have seen a reference to that. So that you've got rival operators. The first point I would make is this: is that if the site is vacant with no one on there at all, then there can, in theory, be competition. Two different operators making their own paragraph 20 applications for the site. Secondly, if you've got an operator in situ, then there can be competition with a rival operator, whether or not the operator in situ is treated as being an occupation. It just affects the question of whether the rival operator's paragraph 20 claim is to be made against the site provider or against the operator in situ. But I would make a number of points. First, the court has a discretion under paragraph 20. It is very unlikely to make an award in favour of a rival operator without a good reason. Secondly, an award in favour of a rival operator under paragraph 20 would not have the effect of determining the existing rights of an operator in situ. And in particular, it wouldn't provide a right to the rival operator to have access to the original operator's ECA. I'll come on to this, but it's a right in respect of land, and the ECA is not land. There are important questions about the rights of rival operators to have access to infrastructure that would be useful for both of them. And that's dealt with differently at a regulatory level by Ofcom. Lord Burrows is absolutely right that in theory one can make those applications, but one can make them whether I'm right or Mr. Pinemont's right.
Is that a sharing of the...
Well,
something different?
The sharing is... if an operator has rights conferred by agreement or by order under paragraph 20, then it has a right to share. So I, Cornerstone, can have got rights subject to the conditions in paragraph 17 to share with EE, with Vodafone, conceivably even with On Tower. Although that's unlikely in practice because we're both wholesale infrastructure.
Sharing the mast rather than sharing the site to allow them to put up their own mast, because presumably the policy is that there shouldn't be proliferation of masts, which is why they have to be
the right is... Yeah, the right is I'm looking at paragraph 17(1)b, page 1819. It's a right to share the use of the ECA. And the ECA is defined. It won't include the whole of the bit of land, but it includes it will include the mast. It includes other structures designed to be used in connection with the provision of ECA. That might include the concrete base. So I think, in theory, that would give us, Cornerstone, the right, if we wished, to allow On Tower to erect another mast at the other end of our concrete base. Pretty unrealistic. But On Tower would have has got no right under the provisions of the sharing provision. They can't. This is a right that we have to choose to share with them. They can't refer to paragraph 17 and please share with us. Instead, they look at the regulations set up by Ofcom, which regulate ways in which operators are required to cooperate for the public good and to share apparatus. And as I understand it, in practice, it isn't a problem that they do share, and that this doesn't cause any difficulties.
Just to come back to the rival operator who goes to Compton Beauchamp and says, we want code rights over that area of land in which there are already code rights for Vodafone or whoever it might be.
Yeah.
And the landowner says, yes, that's a jolly good idea. I'll agree to that. On your proposition, that's perfectly acceptable.
It can do that, but it's difficult to see where that's going to get the rival operator. Because the rival operator won't be entitled to use our ECA. Also, we will have if we have a lease over that, we will have a lease over that land. We will therefore be a person with an interest in the land who's not bound by it. So it's binding on Compton Beauchamp, but it's not binding on us as lessee of that piece of land. In order to make it binding on us, an application is going to be made under paragraph 20, which the court will refuse, one would expect.
You're relying there on the discretion of the court?
Yes.
Not to allow that?
Yes.
But is that right? Because paragraph 21 is quite restricted in terms of what the court has to look at. If the court thinks that both of the following conditions are met, neither of which would seem to meet the sort of concerns that you would have to deal with a rival operator.
Well, Lord, what we say is that there's two things that paragraph 21 does. Firstly, the court is not entitled to make an order unless the first condition and the second condition are met.
Yeah.
And then secondly, we say that if those conditions are met, it has a discretion. And we get that from the word may. And I know that there are circumstances in which may can be read as must, depending on the context. We say the context here is quite clear that may does mean may and doesn't mean must. And one can see that quite quickly by looking at other provisions of the code where sometimes the word must is used and sometimes the word may is used quite intentionally. For example, paragraph 21(4), the very next subparagraph. In deciding whether the second condition is met, the court must have regard, not may have regard, the public interest. Paragraph 23(2) uses the word must, but in 2A, first line, it uses the word may.
Well, your simpler point was that still your equipment anyway, and
yeah, you can do what you like.
They don't do any good,
yeah,
unless your rights, such as you have, can be ousted.
Yes, indeed.
And I mean, I suppose you can get accumulated rights in relation to a particular site. So if you have a site with a compound, but the mast stands at one side and another mast could be erected, not on the plinth, but in the other corner of the compound,
yes.
And that was going to enable improved electronic communications.
Yes.
At the moment, it seems difficult to see why it wouldn't be right to give code rights to the new operator to that extent, even though they would be using part of the land that's been cordoned off and hence in occupation by the first operator.
Lord, we would entirely agree, but to deal with, I'm just trying to think of a case where, so there is that discretion, we would say, and there may be circumstances where it would be exercised.
Well, sorry,
I'm sorry.
What I was putting to you is that maybe, yes, in the sort of situation I was putting to you, it may be that that was a case where the discretion had to be exercised in favour of the new operator asking for the new code rights.
Yes. And
right.
So that might be so. There might be the opposite case where if one mast is put up the other end of the site, it might interfere with the signals from the other mast, or I suppose, in which case it wouldn't be a good idea, and then either one of the conditions are not met.
It would be 21(4) saying you have regard to in deciding the public interest condition as to whether there's an you're improving access to high quality communications, and if you've messed up the signal, you're not.
So, as I say,
21(4), that's parasitic on 21(3). But decide whether public benefit likely to result from making it outweighs the prejudice to the relevant person.
And I suppose the relevant
person would be the landowner there, I'm assuming.
Yeah, well, if it's in the Compton Beauchamp, if we imagine a, I don't know why we're calling it, imagine a situation where the landowner has granted Cornerstone a lease of a little plot of land, and the landowner, and we Cornerstone are using, I've only got a plinth on half of it, and then the landowner grants on tower a right to put a plinth on the other half of that bit of land which has been leased to us. It's not binding on us unless an order under paragraph 20 is made against us. And at that point, the tribunal will need to see whether the two conditions are met, and it will have a residual discretion as well.
I thought 21 operates in the context of an application under 20, where
yes.
you're seeking to get an imposition of an agreement. So the predicate for that is that the landowner doesn't want the agreement. And so you are, in order to exercise the power under paragraph 20, applying the test under paragraph 21, you're overriding his property rights to do that.
Yeah, but
ordinarily he could say no.
Lord, yes, but what I'm suggesting is that there may be more than one relevant person here. That in the example we've given, we would also, we Cornerstone, with the lease of the property, would be the person that the application was made against.
Right. Sorry, the reason I was saying something was more perhaps as a response to what Lord Burrows
yes.
was saying, because I think he was positing, well, you don't really get into the public the public interest question under subparagraph 4 to deal with this notional two-mast scenario where the second mast is going to mess up the signal, because sub 4 is looking at application of the second condition,
yes.
where the public interest comes in to be weighed against the interest of the relevant person.
Yes.
What I was saying is the relevant person, assuming it's the landowner, will always have, under this scenario, his own interest, protect my property rights. I don't want
yes.
to give you
yes.
these rights. And so the tribunal is having to look, well, does the public benefit override that interest to that
Indeed.
extent? And if you put up the second mast and it's messed up the signal, very likely it won't.
Indeed.
I'm sorry to take so long on it, but just to
no,
try and clear my mind of at least one.
Lord, I think I entirely agree.
Okay.
Well, you can reflect on it over the short adjournment and indicate whether your entire agreement is or is not qualified. Thank you very much. Court will now adjourn.